Hello, guys, and welcome back to Inside the Dologist. We're back again like we never left. Welcome back, guys. Thank you. Yeah, Fani Willis, they are still on her case. They ain't giving up on her yet. They are still on her, trying to disqualify her. You know what I mean? Y'all remember the case that's still going on? They're still trying to disqualify her. I don't know if she's gonna survive it or not, but girl, I am loving a look right here. Let's just comment down in the comment section. Isn't she looking beautiful? Oh well, let's just go take a listen to what some of these lawyers gotta say. It's just an highlight, right? And let's use it to comment down below. Let's continue the conversation down the comments, down the comment section. What do you guys think? Do you think she's gonna survive this? Do you think she's gonna be removed? Do you think she's still going to have this and she's gonna bring it? As you know what I mean? Yeah, well, I was just loving it and just let me share with you guys. Because, let me hear your thoughts. Catch up with you guys later. Please do not forget to subscribe if you haven't already. Let's respect ourselves while we comment. It's what's going on and it's what we're talking about. Bye for now.
Benefit or gain, and did it based or got it based upon the outcome of the case. It doesn't make any sense. It makes absolutely no sense. And during the 3 days of any evidence as to or to the contrary of Miss Willis and Miss Wade's assertions of when their relationship began. There's absolutely no evidence that contradicts that the relationship did not begin later than around March of 2022, Your Honor. I'd further submit to the court, because of this failure, that their assertion or their request that, one, the indictment be dismissed. There's absolutely no evidence that the defendants in this case, their due process rights, have been harmed in absolutely any way. There was zero evidence, not a single shred of evidence was produced through any of the exhibits or the witness testimony showing how their constitutional rights, their due process rights were at all affected by the relationship that began in March of 2022 with Ms. Willis and Mr. Wade. And because of that, the motion to disqualify should be denied, and Ms. Willis as the District Attorney of Fulton County and Mr. Wade as the Special Prosecutor assigned to this case should be allowed to remain on this case and continue to prosecute the case to the end, Your Honor, until the trial is set by the court and is to begin. Now, the issues, obviously,
I think you're talking about Business Ventura.
It's McGlynn v. State, McGlynn v. State, 342 Georgia Appeal 170. It's a 2017 case. In that case, as it talks about the standard of proof that the defense, or the burden that the defense must show and go to show an actual conflict, is they say it's a high standard of proof, which is definitely not a preponderance of the evidence, which is a much lower burden for any party who's trying to meet that standard of preponderance. But it's clear that what the standard is that it's a high standard of proof for both when determining whether there's an actual conflict and when there's forensic misconduct that is found, Your Honor. And I want to go through some of the cases that defense counsel has referenced. They argued here today and in their filings, and I guess the bright line standard, or the standard and the grounds for which disqualification is appropriate for Your Honor to be determining in all of the cases as it relates to disqualifying the elected district attorney is that you either find that there's a conflict of interest or that there's been some sort of forensic misconduct. Those are, I guess, the two areas that, Your Honor, that is in your purview when you are looking to resolve an issue regarding disqualification. Now, in a recent case, Levy State, which is 224 Georgia, Lexus 31. It's a February of 2024 case here out of our appellate courts. And in that case, Justice Pinson wrote that a trial was ruled on by the Georgia Court of Appeals about a month ago, Your Honor. Now, the cases in which defense counsel have relied on in their briefs and here today, I would submit to the court the cites are misleading, are inapplicable, and some of them actually support the state's position. And what I would say to you is that the defendants, in many instances, combine language from the multiple cases and kind of what I would say is misstates the law as it relates to what the law or what is required in order for an elected district attorney and their office to be disqualified. And what I would submit to the court is...
Let's go back to that. Show me how.
Yes. Show you how.
So I think the first one they cited was Battle versus the state. Certainly a conflict of interest or the appearance of impropriety would be the grounds of disqualification.
Well,
there are a number of these cases that seem to exclusively rely on the appearance of impropriety.
right.
They acknowledge that there's some ambiguity here, that sometimes Whitworth gets cited to Ventura, and we've got this quote that comes up where it's just they only cite to an actual conflict that must be involved. They acknowledge the ambiguity. You're saying there's no ambiguity whatsoever.
I am saying that, and why I am saying that, why I would submit that to the court, is in all of those cases, they do reference the appearance of it, because they also find there's an actual conflict in each one of those cases.
So your position would be, your review of the case law, there's never been an appellate opinion that relied only on an appearance of propriety.
As it relates to a prosecutor or district attorney, yes. That is what I'm saying. What I would say is, in those cases, they do reference the fact that there is an appearance of impropriety, but they reference that fact because when you have an actual conflict, there's always an appearance of impropriety, and those are what those cases stand for. And I guess that is the main example of what I reference as they kind of combine the language from separate and different cases and tell you that the standard is an appearance of impropriety. And I would submit to the court that is not the standard. And in my first reading, like Your Honor, I did notice that the cases each reference the appearance of impropriety.
No process at the end of the day. It is actually the conduct of the prosecution that should be looked at throughout the course of the prosecution.
Correct, as it relates to how it affects the prosecution, which I would submit to the court ultimately is going to affect the end outcome of the case. If you have a contingency fee based on winning, or how, if you win a motion to suppress and if you win, you get a bonus, as Your Honor referenced. I think that is ultimately going to affect the end outcome of the case, because as Your Honor just said, if there's an instance where an officer is lying, or that where there isn't a good faith to go forward with that motion, the prosecutor would go forward with regardless because of the contingency fee, which not only affects the prosecution at that point of the proceedings, but ultimately is going to affect the entire case, because if they were to win a motion to suppress, or I guess the motion would be denied and the evidence wasn't suppressed, knowing that they didn't have a good faith basis to go forward affects the ultimate outcome of the case. So I think it's twofold, as Your Honor has referenced. I think it's at that part of the procedure of the proceedings would definitely qualify for a reason necessary to disqualify a prosecuting agency, but ultimately that action during the procedure will lead to the ultimate outcome of the case being or hinging upon a contingency fee like the ones in the cases referenced by counsel and the state that are on the screen.